Assalamualaikum. My name is Abdur Rasyid. We are from Group 6 and we are gonna discuss about the Fisher fee bell. These are our group member. There are Fadzrin, Ilham, Nofri, Akash, Amirul, and me, Abdur Rasyid. We are from Group 6. In the significant case of Fisher v. Bell, 1961, the court examined the distinction between an offer and an invitation to trade in contract law. The case arose when shopkeeper James Charles Bell displayed a flick knife with a price tag, leading Chief Inspector George Fisher to accuse him of unlawfully offering it for sale under the Restriction of Offensive Weapon Act 1959. However, the court ruled in favor of Bell, determining that the display was merely an invitation to trade, meaning he was not legally obligated to sell the knife to interested customers. This ruling clarified that a display of goods does not constitute a contractual offer but rather invites potential buyers to make offers. The case is pivotal in commercial law, highlighting seller obligation and customer rights while prompting legislative clarification to prevent future ambiguities. Fisher v. Bell remains a cornerstone in understanding contract formation in retail context.
Assalamualaikum warahmatullahi wabarakatuh. My name is Fadzrin Iszwan and I will be presenting the issues of Fisher v. Bell. Now let's discuss the key legal issue in Fisher v. Bell. The central question in this case was, does displaying the flick knife with a price tag in the shop window constitute an offer for sale under the Restriction of Offensive Act 1959? The plaintiff, Chief Inspector Fisher, argued that the act of displaying the flick knife alongside with the price tag amounted to an offer to sell. This interpretation, if it's accepted, would mean that the shopkeeper, Mr. Bell, was in violation of the Act, which explicitly prohibits the offering of offensive weapons for sale. However, the defendant, Mr. Bell, contended that the display was not an offer but an invitation to trade. This distinction is a fundamental principle in contract law. An offer is a clear, definitive promise to be bound by specific terms upon acceptance. An invitation to trade, on the other hand, is merely a preliminary step that invites customers to make their own offers. For instance, when a customer sees an item in the shop window, they are the ones making an offer to buy when they bring the item to the cashier. The shopkeeper then decides whether to accept the offer. This interpretation raises a conflict between contract law principles and the statutory language of the Restriction of Offensive Weapons Act 1959. The court had to decide whether to view the display as a retail practice under contract law or as a statutory violation under criminal law. Ultimately, the case hinged on how the phrase offer for sale should be interpreted. Was it meant to align with contract law definitions, or should it take on a broader meaning within the context of the Act? This question set the stage for the court's rulings, which clarified these legal ambiguities. Let's move on the court's judgment and reasoning.
Assalamualaikum. Myself, Akash Tarequr Rahman. So now I am going to talk about the judgment, and in judgment there are three things that I am going to explain. First of all, the key legal certification. Second, the court rationale. Last but not the least, significance. First of all, the key legal certification. In this particular section, there's two parts. One is offer and second is the innovation of the trade. So if I want to talk about the offer was a binding proposal or open to immediate acceptance. And second thing, the innovation or to treat a preliminary action inventing offer to giving seller discretion. Here's the point number 2, which is court rationale. Shop display allow to buyers to propose offer with seller retaining acceptance right. Second, the strict of the interpretation of the offer for sale excluded display the from crime liability. Last but not the least is significance. The reinforces of the precision of the legalistic drafting. Second thing is safeguards business practice the against unintended liability. And third is establish the clarity into the correct law and the criminal statutes. And the visual is side by side the comparison of the offer and the innovation to treat in a visually engaging. To conclude, the freshers and the bell rule that the displaying flick knife in a shop window was not offered for sale under the restriction of Offensive Weapon Act 1959, but an innovation to treat the code apply the strict of the press offer for sale within this act, stating that the display did not constitute for a formal offer under the criminal law of principle. The defendant was acquired of the precise the language for the legal constancy. This case said the offer between and the innovation for treat. In overall, that was the judgment in this famous case, which is Fresher and Bell. Thank you.
Ladies and gentlemen, today I address the reasoning behind the court judgment in the case of Fisher vs. Bell, a landmark decision that underscored the importance of clear legal principle and precise statutory interpretation. At the heart of this case was a question: did this display of flick knife in a shop window constitute an offer of sale under the restriction of Offensive Weapon Act 1959? To answer this, the court turned into the principle of contract law and the established distinction between an offer and or an invitation to trade. Let us first consider this distinction. An offer is a definite promise to be bought as soon as it is accepted by another party. It is the first step in forming a binding contract. On the other hand, an invitation to trade is merely an invitation to negotiate or make an offer. When goods are displayed in the shop window, it's not an offer to sell them, but rather an invitation for customer to approach the shopkeeper and make an offer to purchase. The principle is deeply rooted in contract law, and the contract in Fisher vs. Bell applied here. The Shopkeeper Act of placing the flick knife in the window with a price tag was not an offer. It was merely an invitation to trade. Customer could express their interest by making an offer, which the shopkeeper would then decide to accept or reject. Furthermore, the court recognized that the language of the restriction of Offensive Weapon Act 1959 must be interpreted in its legal context. When the Act prohibited offering for sale, it referred to an actual legal offer, not an invitation to trade. To rule otherwise would stretch the language of the statute beyond its intended scope. While the outcome in this case may have appeared at first glance to undermine the spirit of law, the judgment was rooted in the principle that court must interpret statutes according to their precise wording and establish legal definition. Any gaps in the law, the court emphasized, are the responsibility of the legislature to address. And indeed, this case prompted important legislative reform to close the loophole. The law was later amended to ensure that mere display of prohibited items could be considered an offence where appropriate. Fisher vs. Bell is a reminder of the delicate balance between applying legal principles and achieving justice. It teaches us that while the court interprets the law, the ultimate responsibility for making it fit for purpose lies with those who draft it. Thank you.